have two of the panelists. So on my far left, I have my very esteemed colleague, Joanne Collett, who's a partner in the Insolvency and Dispute Resolution team as well. Jo has had a very long-standing association and has contributed a lot to IWIRC, both in Hong Kong and international over the years. And to my left, I have Phoebe Lowe, who is the consultant at Clifford in Hong Kong in the restructuring and insolvency team. Phoebe is also on the IWIRC Hong Kong board as one of the communications co-chairs this year. And in the UK, we have Raquel Agnello, QC of Erskine Chambers, who is a specialist in insolvency and litigation. And finally, we have, but last but not least, we have Juliet Schalker, who is a partner at the head of dispute resolution at Debenhams Ottaway, and I believe also as well the sponsorship co-chair of IWIRC London this year. So this is our panel for today's session. As Shari mentioned earlier, if you have any questions, please feel free to put them in the chat box, and I have access to the questions here. Time permitting, I will ask the panelists the questions. So my first question is to Phoebe next to me. Phoebe, it'd be good to give the audience an idea about corporate structures used in Hong Kong and offshore, and how such structures pose a challenge to or otherwise affect enforcement actions that a client may choose to pursue.
Yeah, okay, all right, thanks, Michaela. Hello, everybody. So I think before we deep dive into the technical aspects of cross-border insolvency and enforcement, we thought that it would be a good idea to give you a 5-minute overview of what corporate structures we see in Asia and some very specific features that we see in the Asian market that greatly impact on our strategies in terms of cross-border insolvency and enforcement. So for those of you who are familiar with the Asian market, there are a couple of points that you will have heard before. The first point that I want to make is that a number of businesses in Asia, even where they're listed, even when they've grown very big, tend to be relatively young businesses. And a lot of times they are started as family businesses or started by a particular entrepreneur who then went on to grow the business and then to tap into the capital markets in Hong Kong or alternatively in Singapore. And because of this, there are signs that with some of these businesses, corporate governance may not be as strong as people in the West and in more sophisticated markets are used to. And there's much less of a division between directorship of the company and its shareholding. We're usually talking about the same group of people or the same 1 or 2 individuals. And as an unfortunate consequence of which, sometimes we do come across mismanagement and fraud. And in the context of insolvency and enforcement, that's sad to say, that's not a particularly rare occurrence. We do come across it every now and again. Not to say that all businesses are fraudulent, but we do see our fair share of that here in Asia. The next point I wanted to talk about is the fact that we operate in a market where enforcement technically is not particularly straightforward in a number of jurisdictions. Jo will expand on this a little bit later, but essentially we operate in a market where we see a lot of offshore vehicles being used, but assets and operations are usually in jurisdictions where the legal systems are also relatively young. So we see a lot of business and operations in China, we see them in Indonesia, and we also see them in jurisdictions like Cambodia and Vietnam. And in these places, enforcement through the courts is not always straightforward. And as a result of which, when we talk about enforcement, it may not necessarily be talking about, okay, let's get a judgment, let's find some assets, let's attach our judgment to the asset, and let's get some money in. A lot of times we're looking for leverage and pressure points to bring the founders or to bring the founding companies to the table to negotiate a deal with us.
Yeah, I think that's right. I mean, one of the sort of key messages from the offshore world, so we deal with BVI, Bermuda and Cayman from this office in Hong Kong. it is true to say that although it can be more difficult depending on what the assets are, the key, if you don't remember anything from me other than this, is that there are things we can do. I'll talk a little bit later about some of the particular strategies that we've come up with in terms of offshore enforcement, and we've had some recent successes offshore. But you know, the most important thing we think is coming up with a sort of coordinated strategy. So we work quite closely with Phoebe's team, for example, sort of on day one to set up, you know, what are the assets and where are they? What are the potential claims? What is the debt? What's the governing law of that debt? And really, what's the structure that we're dealing with here? As Phoebe mentioned, in this part of the world, we do often see offshore structures. So you might have Cayman or Bermuda at the top, come down through some BVI entities, Hong Kong, down to a woofie in the PRC, for example. Something like 75% of the main board of Hong Kong are Bermuda or Cayman companies, with a very small slice of BVI companies. So I think that's why we work so closely with the Onshore Council, and why, frankly, why hawkers are even in Hong Kong is because, you know, we're dealing with those lift codes and any issues in them. You know, the other interesting thing I think in the market recently here is the change in stakeholders. So, you know, years ago we might have been dealing with banks and dealing with bank debt where they might have had a particular relationship with a customer, so they may or may not have wanted to take action. These days, more often than not, we're dealing with distressed funds who have invested, are looking for a particular return, and the relationship issue isn't so important. So there's different factors in the market in terms of what the strategy might look like. So yeah, that's the Asia piece for us.
Thank you very much, Joe, for setting the scene so succinctly. Raquel, my next question is to you. What type of cross-border enforcement matters do you see, or otherwise, what are the recent developments in enforcement have you seen in the UK market?
Thanks, Michaela. We have been in, and I use the words UK market, but as anyone who is qualified in England will know, that there's a difference between England and Wales and Scotland. So if I use the word UK, please remember that I mean England and Wales. I'm not a qualified Scottish lawyer. This country likes to be peculiar and all these things. Now, what are we grappling with over here? We're grappling with 2 points in our market. One of them is COVID, like everyone else, and the other one, of course, is Brexit. So let's just deal with what COVID has done to our insolvency and, of course, in respect of enforcement. Now, since last June, we've had a restriction on being able to wind up companies, winding up by order of the court. It's still available for a very narrow group of companies, those where you can succeed in establishing that COVID has not had a financial effect. So you can see immediately that it's very narrow. And so all those types of petitions where petitioners are seeking winding up orders, which then will trigger recovery, enforcement, actions, are all sort of being held in what I call a bubble. People are waiting and waiting. Now, other insolvency measures are still available: administration, creditors' voluntary liquidations, receiverships, but we're all sort of holding our breath a bit, that we're now going into almost, we'll be heading towards a year shortly of not being able to have the usual flow of compulsory winding up orders. And with the furlough scheme just having been extended in this jurisdiction, I suspect most English lawyers will say, and the restriction on winding up companies will continue. And I can see Juliet smiling, because all of us here are like holding our breaths, you know. When finally they lift it, it's going to be like boom. The lists at the moment, to give you an example, in the companies court, the list would be about 100, 150 every week, sometimes more. And now it sort of barely covers half an A4 sheet when you look at the listing. So just imagine of all that pent up recovery. Now that means that when it comes to cross-border recovery, there are cases here, but the cases from our domestic market where they're seeking to be recognised will not come from compulsory winding up. They will come from administrations, creditors' voluntary liquidations, and those sorts of tools. But a lot of the major fraud cases will normally emerge from compulsory winding up. So there is going to be that pressure. The other pressure we have is to deal with how directors deal with the companies in this area. If you can't be wound up because the court can't wind you up, you're going to struggle to keep going. Now, wrongful trading has also been suspended, but none of the other directors' duties have been suspended. So again, everybody's wondering how to deal with this. And you'll have clients coming to you say, how do I deal with this? You're going, well, let's see where you are. I'm relying on the furlough scheme. How does that operate? Not sure whether that, do you have a business? So all of these things have got to play out. And so, sorry, we're not quite sure where we're going. And then we have to add to that one more thing which has happened here, which is you can't forfeit at the moment commercial leases for non-payment of rent, which means our entire retail business, most of it, is not paying its rent. It's saying, don't need to pay it because you can't forfeit the leases. Again, we're in that bubble, aren't we? We're in the bubble of not knowing what's going to happen until these temporary measures are taken away. So we have all this pressure building up. And then we have Brexit. So let's add another layer to what's happening in the UK at the moment. What's happening with Brexit? Well, I think there's one takeaway message is any insolvency proceedings, meaning your winding up order, your admin obtained before the 31st of December 2020, still allows you to play around with the EU regulations. They work, they operate. It's new cases where you can no longer rely upon it. And so that's one of the key takeaway messages. But that we're still trying to work out. Now, in some respects, as I'll talk about later, it won't make that much difference for cross-border. It makes more of a difference for European recognition, the EU regulations disappearing. So the domestic market is busy, but we've got this like these pressure bubbles building. Recoveries and enforcement will really deal with older cases. But for those who want to come into the jurisdiction, come on in. UNCSA exists, and I'll talk about that a little bit later, but that's a tool which can be used. The doors aren't closed. We may have our domestic bubble, but for those of you seeking recovery and recognition and enforcement over here, the doors are open. They're not the same fetters as we have in respect of that. So to that extent, the message and how we're dealing with it now is a mixed one. We're having domestic pressures, which are temporary, and none of us know where it's going to go. But when it comes to any of you ladies saying, well, I want to be able to come into the UK, come on in, we're in business. We'll open the door. And I'll deal with that a little bit later in this talk. Thank you, Michaela. Over to you.
Thank you, Raquel. It's definitely positive that if we are advising clients about potential cross-border enforcement actions, that they are still available and can still go to you potentially. And but obviously, it sounds like that you may be very busy once all of these suspensions and moratoriums are lifted with respect to domestic insolvencies. So thank you, Raquel, for setting out what the recent developments and issues have been. So my next question is to Juliet. My question is, what tools are available to claimants in the UK to identify and preserve assets, and how easy are they to enforce offshore? Definitely, asset preservation is a big, very important part of our practice.
Yeah, absolutely. Thanks, Michaela. Well, as Raquel mentioned, we still have a very strong domestic market here, and most practitioners are actually dealing with domestic assets day to day. So the usual process is, once we've identified a claim, we'll carry out an asset trace, which can often just be done by the solicitors or the office holders. And that'll involve searching for property, shares, etc. And if any are identified domestically, then we can put watchers on the assets through our land registry here or our company's house here. But if there's a risk of dissipation, or the information about the assets is in the hands of third parties, then there are, of course, tools available to assist with asset preservation, for example, including what a lot of jurisdictions call moravers, although we now call them freezing orders in England and Wales, Norwich Pharmacal orders, as well as an office holder's investigative powers, which essentially allows for a fishing expedition to uncover assets. The difficulty we have is applying these tools abroad, and I'll just touch very briefly on some of the tricky bits. So taking each in turn, the issues with enforcing a freezing order worldwide can be that court approval is needed, which can then lead to delays and sometimes to dissipation of assets. All worldwide freezing orders should include a proviso that the applicant will seek the permission of the English court before steps are taken to enforce the order in another jurisdiction. But applications are generally made on notice, so that can increase the potential for delays. A tip to those who are dealing with worldwide freezing orders is to consider whether to seek permission to enforce the order in jurisdictions where there's a real prospect of assets being found at the outset of the application, because that could really save you time and expense compared to applying for permission after the order's made. However, it may be difficult to do that because the applicant may well be relying on the disclosure part of the freezing order process to try and uncover assets. So that always doesn't work. Other issues with worldwide freezing orders include that they give the respondent flexibility to pick and choose which assets it uses for ordinary and legal expenses. And of course, I would need to touch on cross-undertaking and damages, which can be onerous. There is a possibility for an undertaking to be limited to what is in the estate, but that's really rare. Sometimes office holders may have to give personal cross-undertakings if the estate has limited funds. So it is a bit tricky trying to enforce freezing orders worldwide. Just touching very briefly on Norwich Pharmacal orders, those are usually straightforward in domestic cases, but our law is quite unclear as to whether a Norwich Pharmacal order can be obtained against a respondent in a foreign jurisdiction or where you require disclosure of information in a foreign jurisdiction. Some of those watching will be aware of Norwich Pharmacal order conditions, which is there must be a good and arguable case that there's been wrongdoing and that the victim needs the order to take action against the wrongdoer, and that a third party's just been mixed up in the wrongdoing, often entirely innocently, and often it's the bank. The academic commentary about this is skeptical whether a Norwich Pharmacal can be used out of the jurisdiction. One view is that it can't be sought because a party outside the jurisdiction doesn't necessarily have to adhere to the same restrictions in its jurisdiction as would be imposed here. And another view is that we're not able to satisfy the criteria for good service in such cases outside the jurisdiction. But, as always, there are exceptions to the rule, and some watching may be familiar with the Facebook Island case, which came out a few years ago, where the court allowed a Norwich Pharmacal to be served on Facebook in Ireland. However, this was using the Brussels regulation, which the UK is no longer a party to. And then just to touch very briefly on the office holder's powers to carry out a fishing expedition. Colloquially in England and Wales, we refer to it as Section 236 because the provision is under Section 236 of our Insolvency Act. And it's a brilliant tool, but there are questions over whether it can be used extraterritorially. So the beauty of a Section 236 order is it's really wide in scope. Any person who the court thinks is capable of giving information can be ordered to appear before the court or to produce documents or accounts, etc. And the consequences of the breach are quite serious. There can be a warrant for arrest or seizure of documents. So it's a fantastic tool, but can it be used extraterritorially by an office holder here? There's a raft of conflicting case law at the moment in England and Wales, and the current view is that it doesn't have extraterritorial effect. So to answer your question, Michaela, we have a number of good tools at our disposal, but it can be a bit tricky trying to enforce them offshore.
Okay, thank you, Juliet. All right, so I'll turn back to the panelists who are next to me in Hong Kong. So Joe and Phoebe, so just wanted to put forward a sort of potential case scenario. So you're helping a client on an existing matter. So you've helped the client commence proceedings, and it looks like the client has good prospects of succeeding. However, the client has discovered that the defendant is dissipating assets by way of transferring shares held in the subsidiaries, which are the operating entity, to companies which are outside of this corporate structure. What would you advise your client to do, and how easy or difficult is it in your experience to obtain these types of orders?
Do you want me to start on that one?
Yeah,
All right. I'm going to starting at I guess in my mind, we're sort of starting at the top of the structure, and that's typically where the offshore people kind of live. I think there's two considerations that we look at sort of on day one, which is preserving the pot that we know about. And then we're going to be going on to perhaps at a later stage trying to bring claims or to replenish the pot in terms of assets that might have been taken out. So in a scenario where we've got example of a risk of dissipation of assets or evidence of that, there's certainly things that you can do offshore. We're primarily, again, talking about shares. So, what can you do offshore to make sure that when you get your liquidator appointed in the future, or you get your judgment debt later on, that there's something left. And I think that's always going to be the primary consideration that we're looking at first. In terms of the preservation tools, I think Juliet gave a great sort of overview of some of the English provisions that exist. And what you'll see a lot of the time is that the offshore world follows the English law quite closely in terms of Moravas or freezing orders, Norwich Pharmacal and things like that. So we often actually look to English cases, for example, as to how developments are happening and what's going on. So we try and effectively they almost follow the English law. It's not binding, of course, but it's highly persuasive on the offshore courts. Most commonly, I think, as an insolvency lawyer, my brain probably goes straight to a provisional liquidator on a traditional basis. So where you've got mismanagement or misconduct or risk participation of assets, we can get into court quite quickly. Just echoing or coming back to something Raquel said earlier, what I found really interesting in the COVID situation was that none of the offshore jurisdictions had in place any restriction on people taking steps in relation to coming into the jurisdiction and making filings and proceeding forward. And in fact, what the courts did was in some ways got more efficient because people were putting off long trials to sort of wait until the end of the COVID period. And so it actually became perversely quicker to get listings offshore. What I really liked actually was the offshore courts embraced this technology. So there's been a lot of hearings going on over Zoom. I've just finished a 2-week trial, which was entirely on Zoom, things like that, with a BVI judge sitting in BVI, but then counsel all sitting in London, for example. So they were quite quick to react. So we can get into court very quickly offshore in terms of getting some sort of PL application that can be done ex parte if the circumstances warrant. So the only other thing we look at really is we can get protective orders offshore in support of other proceedings. So for example, if you've got an arbitration going on and you need some interim relief to stop a dissipation of assets offshore, that's something we can assist with under the convention. Similarly, if we've got foreign, you're in a foreign proceeding, then we look at Moravas and things like that. The only other one I wanted to just quickly mention was in the context of secured lending, which often we don't talk about in this context, but I think it's quite important to flag it, which if you've got an equitable mortgage over shares offshore, you may want to, if you're acting for a lender, you may want to consider converting your equitable mortgage to a legal mortgage. The benefit, of course, being what we're trying to do is make sure the shares can't be transferred away. You can do an instrument of transfer and you can transfer shares with the stroke of a pen. There are some steps that need to happen to update a register of members, but it can be quite easy to transfer. The other option is available in BVI and Cayman, but not Bermuda, is to file a stop notice. And that literally just gives notice to the world that, or to the, rather to the registered office, that these shares are the subject of a proprietary claim and they shouldn't be transferred away without giving 14 days notice. It's one of the simplest things in the world to do and can be really effective when we're talking about share security offshore. So I'll stop talking there and hand over to Phoebe. She'll give us Phoebe, you give us the bottom of the structure, right?
Yeah, I will give you the bottom of the structure, but I will gradually work my way down. So I think to echo a number of points made by Raquel, Juliet, and also Joe, we in Hong Kong do have a raft of similar tools that we all discussed just now. So we do have the Morava injunction or the freezing order. We do have the Norwich Pharmacal, so it is entirely possible to use those tools. One tool that we use in conjunction with the offshore lawyers a lot is the appointment of provisional liquidators. In the past, and I'm talking about probably 10 to 15 years ago, it was very common to seek the appointment of provisional liquidators over a Hong Kong listed but offshore incorporated company. I think that was a general practice then because the perception was, well, it's not the jurisdiction of incorporation, but if you look at the company, the management are probably in Hong Kong, bank accounts probably in Hong Kong, and the underlying assets, some of them might still at that point be in Hong Kong. There's been a development in the market in the law away from that. And in particular, over recent years, the Hong Kong court has sort of exercised greater scrutiny in in whether it was appropriate to issue insolvency proceedings against a company that's not incorporated in Hong Kong. So we do have judicial guidance that tell us that unless there's a clear and sufficient connection to the Hong Kong jurisdiction, otherwise the Hong Kong courts would not exercise its jurisdiction over this company. With listed companies in Hong Kong, that's usually not a problem. But if you're talking about a company that's a private company incorporated, say, in Cayman or the BVI, and where you have a founder that spends some time in Hong Kong, sometimes in China, that a sufficient connection might be sort of difficult to make out.
It's interesting, a few years ago when I first got to Hong Kong, it was quite common to see parallel insolvency proceedings for an offshore company. So you would have a liquidation proceeding going on in Cayman and a liquidation proceeding going on in Hong Kong. Now they're quite similar regimes, but not identical. So if you think about administratively all the burden, you're actually running 2 liquidation proceedings at the same time, which just seems, in retrospect, seems crazy, but it was very much the market at the time.
Yeah, definitely. And then taking us to the bottom of the structure now, what we usually have is listed company incorporated in Cayman, Bermuda on top, and some intermediate holdcos incorporated in BVI and Hong Kong in the middle. When you get to the bottom of the structure, chances are you will be looking at a Chinese business operating onshore in China. Now, it's actually not particularly straightforward to ensure offshore creditor claims in China. So, but if a lot of the lenders and particularly the funds have gotten very savvy about lending to this type of Chinese company in the past 5 years or so. Nowadays, people are very aware of the need to have recourse at the asset level. It sounds like a fundamental point to a lot of people, but when, talking about 10 to 15 years back, a lot of the lenders were still lending offshore, accepting that the assets were offshore. Accepting that the assets were onshore. So they would be structurally subordinated to local lenders onshore, which was undesirable. And also without direct recourse to the onshore entities, they would not be able to use some of the tools that are available as a matter of Chinese law. And one very powerful tool is the ability to go in and get freezing orders against certain assets of the debtor company pending the outcome of litigation. So if you had a guarantee that was given by an onshore entity, and that onshore entity, let's say, held a factory, what you could do is you could issue debt recovery proceedings under the guarantee onshore, and at the same time, without waiting for the outcome of that proceeding, you could basically file an application to the court saying that I want a freezing order against this factory. And those types of freezing orders are not like Moravian injunctions freezing orders in the common law world, where the burden of proof is very high, and also you need to give cost undertaking in damages and all of that. So my understanding and our experience is that it's relatively easy to get with a lower threshold of proof. You do need to file a bond into court to support your application, but then there are insurance companies in the market who will provide that service for you.
Thank you, Joe and Phoebe, and thank you as well for also making your way through the structure from offshore into onshore. So with thanks to Juliet and also Joe and Phoebe, we've been able to take steps to prevent further asset dissipation. So now comes the difficult part, which is recovering assets. So, Joe and Phoebe, what would you recommend to your hypothetical clients in terms of recovering assets? What have your recent experiences been?
Do you want me to start at the top again?
Yes, go ahead. That seems a logical place to begin.
Yeah, there we go. Yeah, look, this is sort of the fun bit, right? So look, we're going to be looking at a few different ways of doing this. I think, again, looking at that same structure or page again. But, the idea from what we're thinking really about is, can we do a claim somewhere else and then get a judgment and then bring that into the offshore world and enforce it? We can, in each of the jurisdictions, BVI, Bermuda, Cayman, we have the ability to bring a foreign judgment in, have that recognised, have it domesticated, and then treat it like it were a local judgment and enforced in the normal way. In BVI and Cayman, primarily through the issuance of charging orders, which hopefully might be familiar to the people here, but effectively acts security interest over the shares, get them all about shares. That doesn't exist in Bermuda, but you can get a receiver appointed. So, can we, for example, in Phoebe's example, bring a proceeding against the directors in Hong Kong, get your judgment here and off we go and bring it offshore. Can you bring a claim directly offshore? Do you have an obligor who's offshore that you might just want to bring a claim against, again, with a view to getting a judgment? It can be beneficial, for example, to get a charging order if you've got different creditors who are all coming after the same entity. By getting a charging order, you effectively can put the client in a better position than they might otherwise have been if they've just got an unsecured claim. So although a charging order, a civil claim followed by a charging order can take longer, it might get you in a better position at the end of the day because you can elevate yourself from being an unsecured creditor potentially to being a secured creditor. So again, timing is important there. The other obvious example would be, do I have a debt? Can I bring a winding up petition? Can I put a liquidator in place? Having a liquidator in place, and I think Raquel's going to go into some of this in perhaps a little bit more detail, but having a liquidator in place can be helpful in terms of bringing that liquidator to other places to get recognition and to then try and start thinking globally to then start recovering assets that might be outside of the offshore world. Again, further down, so I'll leave that with Phoebe. So the only thing I'll add to that, just again echoing what Raquel said earlier, when we have a situation where you've got, for example, a foreign liquidator, and I use foreign, so not offshore, a foreign liquidator appointed to a company that's not incorporated offshore, similar to what Raquel was saying, come and talk to us. Each of the jurisdictions has their own method of recognition, either in the statutes or at common law. None of them have adopted the UNCITRAL model law, which again I'll leave to Raquel to talk about, but none of them have that in force. The BVI has actually brought it in, but the provisions are not in force, quite strangely. So none of them we have UNCITRAL, but each of them have their own way of dealing with requests from foreign liquidators of foreign companies to come in and seek to enforce and recover assets offshore.
Okay. I guess my 2 cents to that would be a lot of times when the company's insolvent and let's just say a liquidator is being successfully appointed offshore, what the liquidator would do would be to try and drill down through the corporate structure. So change the boards of all the subsidiaries, drill down to the asset level, and then try to sell the business, hopefully as a going concern in order to make a return for the creditors. So I think that, Joe will correct me if I'm wrong, but the process of drilling down through BVI companies, down through Hong Kong companies is generally a straightforward process. As long as you have control of the ultimate shareholder, you can pass shareholder resolutions, then there might be, the process might be longer, it might be shorter, but you'll be able to get there.
Yeah, we generally will include in the orders that we're seeking offshore, we will include an express power of a provisional liquidator or an official liquidator to exercise shareholder voting rights to change boards of subsidiaries for exactly that purpose. So again, we're looking at a coordinated strategy. So we're going to be working that out before the order is made. So what you actually do is cascade down through the structure. We do have to check, obviously, the constituent documents of each of the entities. One little wrinkle can be if we don't have them. For example, Cayman are not available publicly, BVIR. It's just a difference.
Or if they've been secretly amended without your knowledge.
Or if they've been secretly amended.
that happens.
That's happened. There's obviously a story there. So, it does take a little bit, again, it's basically thinking about this stuff and planning it. And again, ideally going through the structure. Similar, actually, I should have added before, again, going back to the secured approach, if we've got a receiver, we've got powers to appoint a receiver to voting rights of shares, we can do the same thing. So that's an out-of-court process, come in a receiver up the top and again cascade down through and deliver up a new board to Phoebe, who can then try and get actual operating assets. There are some wrinkles on registered officers and changing registers of members. I won't go into them, it can be a bit of a nightmare, but certainly a strategy we would consider.
But I think it's fair to say that to the extent we run into those wrinkles, they can be ironed out by a bit of effort. They're not a complete, roadblocker.
True.
But where you might actually end up with a complete roadblocker is where you get to the bottom part of the structure, where you try to cross the threshold from the offshore world into China onshore. And that's where the wrinkle happens, because from my understanding is that from a Chinese law perspective, and I have to, disclaim that I'm not actually qualified to practice Chinese law, but then we in Hong Kong do come across aspects of Chinese law, and we work very closely with lawyers in China. But essentially, what might happen is that whilst, let's say we have to take control of a Chinese company that's held through a Hong Kong company, or Hong Kong intermediate holding company. So the liquidator has taken control over the Hong Kong holdco, and then it's exercised the Hong Kong holdco's power as shareholder to try and reconstitute the board of the PRC company. Now, in theory, that should be permissible as a matter of PRC law. But in practice, what you need to do to get the new board recognized is you need to make certain registry filings in China, and you need basically the local authorities there to help you update, the public register of directors. And that's where you might run into issues if you don't have the cooperation of the outgoing board, so to say, and particularly if the outgoing board has a certain level of local influence, and that's not uncommon in our experience. Particular issues might arise if you don't have control of the PRC company's company chop. That will be a very important. So the official won't recognize, resolution signed by some offshore liquidators. They will be very, very keen to see the company chop affixed on the.
Explain what the chop is.
Okay, the chop is a secret instrument.
I didn't know what was from in Hong Kong. So.
Yeah, well, it's actually it's not dissimilar to our concept of a common seal. I know that you guys have gotten rid of it under English law. I think most English companies don't have a common seal now. Some Hong Kong companies still do have a common seal. It's not quite similar concept to Chinese law, which is if you have the company's chop, then that's basically a rubber stamp you use to sign contracts with. So as long as a contract is affixed with a company's chop, then you don't even need a signature. You just need somebody to put the chop on it, and it's legally binding on the company.
It's really important.
It's a very important instrument. You can't, if you don't have it, it's going to be very difficult to overcome that obstacle, because nobody, I think you can't really do anything official without the chop. So that's a potential issue that you might run into when you're onshore, and not to mention the practical issues of taking control of the onshore operations, trying to manage employees there who might not necessarily trust you or know who you are if you're a liquidator or other office holder.
Is it possible to get an order from one of the PRC courts to get a new chop in your experience, or once the person has run with the chop, then it makes it very difficult?
It's I've not really come across it before. I suspect that it's actually theoretically possible, but practically very difficult.
The other, the idea of this, there's a concept of a legal representative. So yeah. I think the approach, and actually what I've seen against being in Hong Kong is, when I first got here, it was basically impossible to do anything. I think the courts in the PRC, from what I'm in China, mainland, what I'm seeing is that they are actually getting more open in that regard, and you can go to court and get orders basically changing the legal representative. So not necessarily getting new chops, but at least changing that person.
A step in the right direction.
Yeah, exactly.
Yeah, but because of all these difficulties, what we would usually advise clients at an earlier stage is to try and get guarantees from the onshore entities to make sure that you have a direct right of recourse against them. If you do that, if you have a guarantee against given by an onshore entity, then it's much easier then to sort of go in and try and get a freezing order, for example, or to commence a simple debt recovery claim. And then you don't need to worry about issues of structural subordination, where all the local creditors are able to get in before you do, and you might be able to find a way around, the issues that might arise in terms of taking control of the onshore subsidiaries.
The other recommendation we tend to make is, if you can, may not be possible, but is to get personal guarantees from the founders who might themselves have assets offshore. So we've had a couple of cases recently where we had judgments in Hong Kong that were then taken to BDI as I said, domesticated or recognised in the BVI, charging orders, changing boards, and then just enforcing over the assets of the offshore company, which happened to be shares in a listed Hong Kong company. So taking a judgment out of Hong Kong and then coming back to Hong Kong to sell some shares by way of a new board. Similarly, we had another matter where we had a judgment against a founder in the PRC. This is the first time I think this happened, where we actually took a PRC judgment against an individual. Again, he was holding shares in a BVI company. In that matter, we actually got receivers appointed we got charging order, but we also got receivers appointed for the purpose of changing the board. And again, in that one, we were able to go ahead, change the board, have the new directors sell the assets, again, Hong Kong listed shares, and pay the money up to the creditor. So that didn't involve going back to PRC at all. So that was starting, and that was sort of start at PRC and bring it offshore rather than starting offshore and going down, if that makes sense.
Yeah,
so there's
and
things we can do.
it's actually not inconceivable that lenders might have a personal guarantee. I mean, the concept might be a bit foreign if there's a massive separation between shareholding and directorship. But in an environment where basically the director is also the sole shareholder or majority shareholder, and he's used to it being his empire and running it the way he wishes, sometimes they will actually give a personal guarantee.
Yeah.
Well, thank you, Joe and Phoebe. I think it's actually good as well to dispel the notion that enforcement in PRC is practically impossible, because that's definitely a perception out there that that the EMAs will give up before you get into the PRC. But it's actually a very good development that the PRC courts especially are being a bit more receptive about assisting with recognition and enforcement. So Raquel, I wanted to ask you about what are your experiences with recognition of offshore provisional liquidators in the UK?
Thanks for that, Michaela. I think that provisional liquidators are quite easily recognised in the UK, and as Joe says, that's the immediate thing they consider about insolvency. They are recognised. I mean, I think when you look at recovery options in general, what I was going to talk about Angstral, and I will talk about Angstral as well, but our recognition of foreign office holders and foreign insolvency proceedings is very much based, the starting point is always ignore the EU regulations, the common law of judicial comity, which is alive and well. And I always find it quite cute that we're still talking this old-fashioned language rather than trying to put it into some statute. And I'll give you an example of what language we're talking about in comity, because it's worth remembering this is still the basis of our recognition unless we go through Angstral. And it's the courtesy accorded between states or their courts on the basis of accepted rules of mutual conduct as between state and state, which each state adopts in relation to other states and expects states to adopt in relation to itself. Now, in this current day and age, and without getting too political, with populist options and nationalist ideas, it kind of is quite amusing to me that that's still the basis of recognition of foreign PLs over here and other such insolvency proceedings. But what you find, despite the politics of it, is that as a basis, the common law of judicial comity isn't bad. You go back to BCCI, and BCCI showed you how the judges were cooperating. Nortel's a more recent example, and that keeps going. But there's two possibilities for recognition of overseas office holders, and this deals with asset recovery as well. You can either bring your PL over here and then ask your PL, and the PL wants to get recognized, and I'll come back to that in a moment, or you might want to get a judgment overseas and then bring that judgment over here. Let's start with option one. You've got your PL, there's some assets. You want to use Juliet's freezing orders and want to freeze something over here. So you want to come over here. Now, you can either go through Angstral, or you can simply come along to the court and say, I'm an overseas PL, please recognize me. This is what I want to do. And I always find it very odd. Angstral is available, and it is, roughly speaking, our Chapter 15 recognition, and yet it hasn't had as much use. And one of the reasons it hasn't had that much use is because you can still go via the common law option, and it's available. You don't need to use Angstral. UNCTRAL is probably a codification to make it simple. If there's one message to take away from UNCTRAL, is that it doesn't base itself on reciprocity. I think it was either Joe or Phoebe who mentioned that UNCTRAL has been signed in the BVI but not ratified. The UK, somewhat uniquely, I think, is that getting too political, has signed and ratified it without putting in a reciprocity provision, which means that anyone can come in and be recognized. It doesn't matter where you come from. It doesn't matter whether you have ratified or not UNCTRAL. So it's just come on in type thing. And the thing to remember about it is that, and again, you could go under the normal common law sphere, but if Jo's got her PL and wants to act urgently, you can do the recognition at the same time as you do your freezing order, a la Juliet, and at the same time you seek anything else. You can do it all in one package. If you want to do it separately, you can. And to just give you a feel for it, if you come along to get recognition, the minute you get recognized, you get an automatic stay. Now, we need to talk about abusive proceedings in a moment, but that automatic stay means that as Jo's PL comes into this jurisdiction, gets recognized, immediate stay. Now, that may help you in respect of any creditor enforcement, and that may be enough. But you can also say, I would like to get the freezer at the same time. Yep. And one of the ways that UNCTRAL works is that once you come over here and you get recognized, you have all our fun insolvency tools at your disposition. So you want to use 236, if you have the conditions, off you go. You want to freeze, off you go. You want to do this, you want to do that, off you go. You can even use it and come in over here, get a judgment over here. And this is similar to what you ladies have been talking about, and then take the judgment from over here and seek to have it recognized offshore. You can do that too. Yep. Now, of course, you need the facts and everything for that. What you can't do when you come over here to be recognized is be what I call sneaky. Sneaky is not the way to go. And what I mean is you come over here and you try to get yourself recognized, because what you're really trying to do is to get the stay because you want to stop, for example, arbitration proceedings going on. Yes. Yeah, that's a no-no. I mean, we all know that. Sneaky is not the way to go. When you make an application for recognition, it is very much, and this sounds very rude to say, you meet the conditions, you get it. You need a collective insolvency proceedings. Provisional liquidation suits that. Certain types of receivership may not, yes. But once it's a collective proceeding, either administrative or judicially supervised, you can come along and be recognized. And there's lots of other things. But once you have all your paperwork in order, the court just goes tick, you're recognized. And if your main proceedings, you get the automatic stay. But the other side can come along straight away and say, hey, lift that, because I've got an arbitration starting in 2 or 3 weeks' time. They've known about it. This is just a ruse, yes? And so when you make your application to be recognized, you have to do full and frank disclosure. So you have to inform the court of what effect the recognition may have on third parties. And you also have to notify the court as to what your proposed action may have. So let's say you do your little combined. I want to be recognized, I want the stay, and I want my freezer. You're going to have to explain all of that and explain to the court, well, I want to go straight away for this freezer. This is why. Here's my dissipation evidence. Can I have that? Yep. So it's easy, straightforward. It's codified. You can go under common law. It's not been as heavily used as I think it would have been when the UK signed up to it. We could be here all afternoon as to why, or all evening, or all morning as to why. I think that a lot of recognition procedures in Europe use the EU regulation. I think we're going to find in the UK more use by EU states of coming in here under UNCTRAL, because we're no longer into the EU regulation, yes? So there's lots of fun and games that you can do there. And I think that it's a very useful tool. We also have for offshore, we have 426 where you have cooperation given, limited very much to the Channel Islands, the Isle of Man, entities like that. So it's of limited use, but you can use that as well. Now, let's go on to the judgment. Let's say instead of bringing in your office holder here, you've got a judgment you want recognized, yes? Now here we have to be a little bit trickier here. And the reason for that is most judgments, again, will get recognized under common law. You bring the proceedings, yes? But you need to be a little careful. When you go through UNCTA trial, you've got your insolvency office holder's hat on, yeah? When you come over here and say, I've got this judgment, we don't believe in universalism to the extent of saying, hey, insolvency office holder, you're absolutely great, of course I'll enforce it. Ruben, Eurofinance is still the law here. So if you come in with a judgment, the court is going to here screen it and say, well, is it the sort of judgment we would enforce over here? And it doesn't matter that you're the office holder and on the side of the angels, so to speak, the court will still say you have to comply. So you have a restriction. So when you're looking at what you want to do, it's always a good thing to think, if I get my judgment overseas, can I get it recognized in the UK? Or I'm better off bringing the proceedings in the UK, because then I can be like an English office holder. So that's something that is worth thinking about, because Ruben and Eurofinance still exists. Now, just before I finish off, I think it's worth dealing with one thing, which is the big buzz here in the UK as well, not just COVID and Brexit. Well, this is related to Brexit, is Lugano. The Lugano Convention is where you have recognition of foreign judgments. And the one thing I would say is it's restricted to civil and commercial matters, yes? So if you are a provisional liquidator, a foreign, an overseas office holder, and you have a judgment, if it falls under the classification of a civil and commercial matter, then it can fall under Lugano if the UK is ever allowed to enter in. At the moment, the others are telling us we're not playing nicely enough. And so if we're not behaving, you can't join. Typical attitude, isn't it? But if you do get into Lugano, you need to make sure your characterization of what you're doing, yes, falls under civil and commercial. If it doesn't fall under civil and commercial, then Lugano is inapplicable. So you're left with recognition under that old-fashioned comity I was talking about earlier, which is why I quoted it, because we're in 2021 and I'm quoting old-fashioned sayings from the 60s or the 50s. Kind of dumb, isn't it? But that's the way it works. So if we do bring Lugano in, it may not be the wonderful solution. And for those of you following, we've recently had a decision of Mr. Justice Zaccaroli, and this isn't in recognition and enforcement, where he observed that Lugano does not apply to our restructuring plans, which come over here. So he's putting that clear demarcation between insolvency and civil and commercial. Happily, and I say this happily, most of the actions brought by overseas office holders may not necessarily be classified as insolvency. You may be the claimant, but you need to characterize the claim you're bringing. And when it's like disputes, shares and things like that, it may actually still be a civil and commercial matter. So I think that's my time over with, but back to you, Michaela. I hope I haven't gone over my time.
No, that's fine. Thank you, Raquel. And it'll be interesting to see how the post-Brexit landscape plays out as well. I think we've got time for one more question, and then I'll see if any questions have come up on the chat box. So we've covered asset preservation, asset recovery. Now, the final question that I have is, even if your client has excellent prospects of success, if there is little prospect of actually being able to recover assets, the client may not wish to expend money on lawyers and insolvency practitioners and others to help recover these assets. So litigation funding has become a buzzword lately in this space. My question is to Juliet. Has it gathered a lot of momentum in the UK, and what are the current trends?
Yeah, absolutely, Michaela. I mean, litigation funding in the insolvency space became popular a few years ago now, and it's really taken off. As a result, it's also led to new market players coming on the scene a few years ago now, buying up claims through assignment from office holders, because of course, insolvency is an exception to the championing and maintenance rule over here. So funding or assignment is now very much part and parcel of the UK insolvency claims market. But there was a shake-up a year or so ago with the lifting of what we call over here the Arcane Cap. It's called the Arcane Cap. It's based on a case that came out here in 2005, which limited a third-party funder's potential adverse costs or liability to the amount of the funding that they were providing to their client. So as a result of that decision in 2005, it led to a lot of funders entering the market on the basis of this limited liability. But the Arcane Cap has been diluted in recent years. And very recently, the Court of Appeal decided to disapply the Arcane Cap altogether and not to limit the funder's liability to the amount of that funding. So now courts will actually consider the funder's potential return on investment and may in future equate this to the potential liability. So the question that we've been grappling with is, will this discourage third-party funding in the insolvency space in the UK market? Well, the answer is unlikely. It could lead to more extensive after the event insurance ATE policies being sought, but the funding market here is still incredibly frothy.
Thank you, Juliet. Joe and Phoebe, what have been your experiences with respect to litigation funding?
Shall I go first this slide? Okay, I think it's fair to say that there are a number of very keen funders in our market looking for opportunities. That said, the litigation funding market is not as developed as it is probably over in the UK. So we do see a number of cases being funded, but I would not say that getting litigation funding is something that's very prevalent or is the norm. So a lot of times, office holders are still pursuing claims with the resources at their disposal and assets in the company. An issue that we come across every now and again when looking at these types of litigation funding proposals is an enforcement issue. So I think because we come across a fair amount of fraud and mismanagement, it is often the case that there will be claims. The claims will be meritorious claims, so you're not really talking about 50-50 claim. It's a lot of times, putting aside delaying tactics that may be taken by the other side, these are actually good claims. But where we fall at the hurdle every now and again is enforcement, because a lot of times the fraud will have happened for years and years. The proceeds of the fraud might already have been dissipated. You can't trace them. The fraudsters might be long gone. They might have absconded back to mainland China or to some other jurisdictions where it's very difficult to trace. And in those circumstances, the funder's going to go, well, yes, I can see that there's a good claim, but how am I going to get my money back?
What's actually interesting about that is you've just taken us right back to the start of the panel. What Phoebe said at the very start of the panel, you've just taken us straight back there. I quite like that. I'm conscious of time. I won't take up too much time other than to sort of echo what Phoebe said in terms of the offshore market. Been around for a while. Insolvency claims in particular have been around. We have the usual liquidators tools to try and replenish the pot, which I talked about earlier. The only main update for me is that the Cayman Islands now have a statutory basis of funding, which has come in. So that's helpful in the sense of, again, moving that market forward and getting funding to be available.
Okay, well, thank you very much. I see that we do have one question from the audience, so perhaps we'll get this question answered and then we can close the panel. So Raquel, the question's for you. Did I understand correctly that a foreign IP can, after recognition, use English tools, no matter whether his/her jurisdiction, lex concursus, offers similar tools, i.e. his or her powers may be expanded through recognition in England?
Thanks, Michaela. Yes, I think that's from Robert. Yes, the answer is that is possible. And here comes the caveat all the time. If you want to use the tools which are available in the English jurisdiction, which are not available in your own jurisdiction, you need to be prepared that the other side may say that's against our own domestic law. So you have to be prepared for that. And that it would be against English public policy to do that. So the answer is yes, it's possible. That's what UNCTAD does. UNCTAD also, by the way, and this has been tried before, allows you to rely on the foreign insolvency proceedings, the foreign law, insolvency law, to try to get that recognized in the UK. That's another story. But the answer is potentially yes, Robert, you can, but you need to be prepared to have some argument about whether it's an appropriate case to do so. I mean, let me give you an example. 236 you can probably do and ask questions. If your jurisdiction, and this is a silly example, let's just give it, doesn't have preference claims, and you want to come along and do preference claims, and your jurisdiction has expressly selected not to have preference claims, then you may have a little bit of a discussion about that. It's possible, but you'll need to be aware to explain if it's just a lacuna in your domestic law, which happens, it's not been thought about, then you'll have more of a chance. So the answer is potentially yes, but you can't say, oh, well, Raquel said it was okay, so I'm fine. No, you need to put it into your context. I hope that helps.
I'll just add to that, just to give a flavour from the offshore world, is the answer offshore would be no. So there's Privy Council authority, in this case with Singularis, which confirms that a foreign liquidator coming in cannot get more powers than they would have at home. So it's interesting, I think, again, just in terms of the different jurisdictions, that we would be advising probably the opposite.
Okay, well, I want to say thank you very much to the panelists, Phoebe, Jo, Juliet, and Raquel. I feel like we could have a full day seminar on the topics we've covered today, but unfortunately we only had 1 hour. We hope that we can have another panel again soon, and thank you very much to Shari for getting up so early again and for setting up the panel. So we will let Shari continue with the rest of the conference, and thank you very much everybody for your